us the papers because of you and because of the hosts and the professors and everyone that supported it. So thanks very much for being here, and welcome to Brazil. I'm here in Rio, so whenever you want to come here in Brazil, just let me know. And I also have my journal here, the Brazilian Journal of ADR, of Alternative Dispute Resolution. So if you're interested in arbitration, mediation, or any types of ADR, just send me a paper and I'll publish right away. And I would like to thank Professor Elizaveta, who helped me and who worked really hard for this conference today. So thanks, Professor. You are the best. I'm your fan. You know that.
Thank you so much. So, and we are waiting for
the live stream, right?
Yes, and we are waiting for Elena and Eleonora.
Oh, okay.
So, okay. Eleonora is here, so she's right.
Yeah. Elizaveta, we are already live on YouTube. Alfredo just told me, so yeah, we better start.
Okay, so let's start. Oh, I think Daniel, you will start.
Okay, so thanks everyone for being here with us. This is the conference on law and digital technologies, and this conference is hosted by Umbra University, by Universidade Candido Mendes, I should say that in Portuguese, and by South Euro State University. So these partnerships between the programs are going really well. And of course, and this all started in our study group on ADR, law, ADR, and digital technology between the universities. So it started small, and now it's becoming bigger and more international, thanks to each and every one of you. I should thank all the participants that sent the abstracts. We had 80 authors in total. We had 108 participants. So we can consider this a big success for the first version of the conference. And we're doing it yearly. So next November in 2022, we are going to have another version of this conference. I should thank all of you professors for being here today, and especially Professor Elena for bringing BRICS Law Journal to the conference, and that really helped to make it successful, and Professor Eleonora also for the Bologna review also. And so this attracted people a lot more, and because you have high quality journals. So thanks for being here, and of course all the professors, and last but not least, I think the most important person here is Professor Elizaveta, that was really careful reading all the abstract and reviewing it, and doing most of the job was done by Professor Gromova, not by me. So thanks, Professor Elizaveta, for being this journey with me and with all our students and in our research group. So the floor is all yours now to present our lecturers. Oh, I should thank also Umbra University and Alfredo, our director here, because without them, we wouldn't have the technology and all the platform to review the papers and everything. So the support of Umbra University, which is in Florida, was absolutely awesome. So Elizaveta, do you have any trouble? Oh, her microphone is not on, has failed a little bit. So I should do you have can you send me the short resume, the short bio of the lecturer, so I can introduce them? If you can, just do it through WhatsApp if your microphone is not working. Okay, so the goal of this conference was to be an international hub for research in digital technology. And I was really glad because I'm an ADR guy, researcher, and people, we received a lot of papers on ODR, on online dispute resolution also. So, and that was my goal here too. So we have a lot of interesting papers from all across the world. Elizaveta, is your microphone on? Oh, no. Nope. Nope. Damn. So I think you should leave and come back. What about? Yeah, probably that. Try it. So I don't have your short resume. It's with Elizaveta, but let's just begin. Sorry about that. I know that. Let's start, of course, with the ladies. This class I didn't skip here in Brazil. So I will start with alphabetical order, let's just say. So Elena is the editor-in-chief of the BRICS Law Journal and a professor in Russia. I can't really pronounce your university, Elena. I know it's Tulami. I don't know. It's it's Russian. So please just start your lecture here and let's begin. Thanks
Thank
for
you,
being
Daniel.
here.
Very happy to see you again now in Brazil, not in Russia. And I'm going to speak about this, how we can travel very easily and very cheaply to different places and to see each other. I wasn't supposed to be the first one, but it's okay. I can start, and I've got a presentation.
Go ahead, just share a screen.
I can share it. Is it okay?
Yeah, perfect.
Yeah. Can you see it? Is it full screen?
No, it's not full screen. It's just
I'm trying to.
We can see, but it's not in the presenting mode.
Yeah, yeah. Yes.
Now you got it.
Yeah. And first of all, I introduce myself. Elizaveta was supposed to do this, but it's okay. I'm from Siberia, from Russia, and my university's name is University of Tyumen, or Tyumen State University, and it is one of the most interesting one in Russia, I think, because it used to be a small regional, provincial, as we call it, university, but within 10 years, maybe, it has been so dynamically developing, and it has been involved in many Russian large-scale educational and research projects and international projects. And by now, it is one of the most, not the biggest one, of course, but one of the most famous because of this dynamics, because of these changes and new challenges and opportunities. Our university is quite well known, and I'm proud to be affiliated with it. And one of the projects of our university is the journal, which is also dynamically developing, and I'll tell more about it. And I'm since last year I'm the editor-in-chief of BRICS Law Journal, but I became an executive editor of this journal in 2016, and also as a researcher, as a professor of University of Tyumen, I'm involved in many other different projects, and I'm the member of some scientific boards in Finland, in Lapland University, for example. And thanks to Daniel, I'm also in an academic board of his center and editorial board of his journal. I'm doing different research projects, mostly in the area of indigenous issues and sustainable development issues in the northern territories, as Tyumen is closer to Arctic territories and then to some of BRICS countries, of course. But here are two dimensions of my work, of my activities. And today I'm very happy to be here to be the partner, as Daniel said, and to be the speaker of such an interesting and notable event. And this conference has attracted so many different scholars and practitioners and researchers from many countries and so many disciplines. And the topic of the conference is very relevant. Now we live and we are finding ourselves in a very exceptional time of global situation. On the one hand, it's difficult. On the other hand, it brings so many opportunities for us to meet, to discuss issues online, to become friends online, and to become collaborators and partners online. So I think we are all happy about this, and we all glad to be here to use technologies that bring us together. And my topic today, I would like to speak on two closely related issues. So first, what is academic cooperation now in this digital world and changing world, and how this situation, how this digital world help small projects, regional projects, become international, become well-known. So I try to speak on this, but unfortunately I can't. Well, first of all, I would like to mention that I have already mentioned it, that our life is changing very dramatically, very rapidly, and the world on the one hand seems very dangerous, turbulent, unpredictable now, but on the other hand, and as university researchers, as lawyers, we feel some bigger responsibility to help our nations, to help our citizens, to help our communities, local communities, to pass through this turbulence, to try not just to survive in these difficult circumstances, but to become stronger, to become more internationally and personally active and interesting, so to say. And on the other hand, much more opportunities have appeared since February 2020, March 2020, when we found ourselves in this lockdown situation, in a situation when we cannot go anywhere, we cannot even go out, couldn't go out from our houses. But in that time, we noticed, and since that time, that our landscapes, teaching landscape for the universities, academic landscapes, research landscapes have been changing. And to my mind, they are changing in a good sense. So we are experiencing and we are facing much more opportunities than challenges. And in this way, digital technologies create new landscapes. And these technologies make all our collaborations cheaper, faster and more effective. That is my opinion. And I think, as an example, for example, since September of this year, I have participated in 15 different events, including roundtables, workshops, webinars of different kinds. For example, I am the participant of 5 international projects, and all these projects provide and do some webinars, and I'm participating in all different events constantly. So before 2020, we didn't have such an opportunity. I think it's a good sign that we can be more active, more flexible. And also digital technologies create more efficient, more effective academic networking. We meet new people online, which means that we can spend more time on our research, but at the same time we can meet very quickly online. So that is a good thing also, in my opinion. And our personal research, as a researcher, as a scholar, as a part of faculty, I think we all have noticed that our profiles also have been changed greatly. And many scholars now create different digital profiles, websites, join academic social networks, and make And these technologies also help us to become more visible. We can conduct joint and individual research, like in the legal area, for example, in legal research. We can build networks more easily, and we can expand our cooperation, not only on the national scale, but also internationally with international partners and international colleagues. Also, we can promote our research more easily now. So we can not just do some research, but we can also share it with people around the world, with scholars around the world. And these new profiles also and new research landscape also create many opportunities to raise interest towards our research. Like in Russia, for example, of course, there are very many legal areas, relevant legal research, which our scholars are involved in, but only recently, I think we got many opportunities to present the results of our research via, for example, different academic social networks, via different research database and via journals where we publish. And it, of course, make international research community more close and more experienced, because we can see the results of each other and we can share these results. And as an example, I can bring different examples of social networks. I think we all are members of Google Scholars, ResearchGate, Mendeley, and other networks. And this is great. So we can easily get some information. We can easily share the information about ourselves with the international academic community. And as an example, how to become more internationally involved and active, I would like to bring the journal of our university, which is called, you've already seen this, BRICS Law Journal, and it happened in Tyumen University in 2016, a little bit earlier than a pandemic time happened, but this was a decision of our university to create some internationally recognized platform and some international recognized forum for lawyers, for practitioners from all around the world to communicate and to share their results of their research work. And in 2016, the University of Tyumen has become a publisher of BRICS Law Journal, and the objective was to create this local forum and to reflect issues which are relevant to the BRICS countries, and maybe not just to BRICS countries, but internationally significant. And BRICS Law Journal became the world's first legal academic journal, associated with the BRICS group, but now we are going further and we accept papers and research results not only about BRICS countries and not only about legal issues. But when we established this journal, we faced very many challenges, and it was very kind of dangerous for us to step this way, because, as I've said, our university was quite was a regional one, and for us it was very unpredictable how we could do this. But we went through different paths through this path, and what we created a platform for scholars, for academic community, and the journal involves many scholars from Brazil, Russia, India, and other countries. So our geography of the journal is very diverse. What is the result of all this? And first of all, we helped our university academic colleagues and university faculty to become more internationally visible, so to say, to present on the international platform. We managed to create a network of professionals and experts in legal field, in social field, and it made our university more so to say, not famous, but recognized. And also we have known very many people in different legal areas who have studied, who study, for example, environmental issues, energy issues, sustainable development issues, civil tort law issues, and other. Also, this digitalization and globalization process help us and as a journal and help our academic help our faculty to share ideas, to share their results and expertise. I think that platforms and journals like this help also to make legal research more advanced, because we can share the experience of different countries. We can make comparative research, and it makes our research projects more efficient, more helpful for citizens, for peoples, for communities in our countries. But still, despite of all this, still there are many gaps in international collaborations, and very many not problems, but challenges remain. As an example, I would like to bring this statistic, and you can see that the biggest number of papers in research journals, for example, in BRICS countries, are created by scholars within one country. For example, the biggest number of papers are joint papers in co-authorship are created for example, with Brazil researchers, scholars in Russia, and so on. And there are not very many collaborations, not very many joint projects within and among scholars in India and Russia, for example, in China and Brazil, and so on. And as a journal, at the editorial, our editorial board also helps scholars to become closer, to create networks, to create joint projects, and I think we succeed in this. And there are many examples of good research teams which have been created at our journal platform. So speaking about our journal, I think that we have managed to become an open forum, and our project creates opportunities to cooperate and to conduct joint research on relevant topics, and started with just several agencies where we have been presented. Now we are included in many databases, and very big number of libraries and subscribers and countries have access to our journal via Scopus, Web of Science databases, Hein Online, and so on. I think that such projects, such internationally significant projects as our journal, or we can bring some other examples, they do very important things. So first, they inspire discussions between, not just within one country, national wide, but between lawyers and colleagues from different countries. And this contributes to international collaboration. Journals and digital technologies and digital cooperation develop networking, and this networking and the results of projects are really becoming internationally recognized. And this encourage interests in legal areas, in social, economic, and other related areas. It can be said on BRICS countries, but it also be done. It also can be done on any with any other focus. Well, as for the topics that we cover in our journal, they are related to the pillars of BRICS association itself. And we have very many, big diversity of different papers, but mostly we try to involve our authors in researching such issues as politics and global governance, sustainable development, trade, financial cooperation. And the recent issues of BRICS Law Journal are mostly devoted to science, technologies, digital economy, digitalization of law and legal studies, innovations, energy. And also very important issues are people-to-people contacts and humanitarian cooperation. So if you are interested in being involved in international collaborations, on academic collaborations. I think such projects as international journals, international research projects is a very good opportunity for scholars to be involved in globally significant issues, be more efficient in our job, and be more important in our countries, as we can promote new ideas, new quality of research. So that is why, well, my conclusion is to encourage young scholars, experienced scholars, practitioners to get involved in such international projects and to become authors, to become readers, to become partners of projects like that, like what Daniel is doing in his university, what we are doing at the University of Tyumen, and many other universities and research journals try to do this now, because technologies afford us to do such internationally significant projects. Well, I think that is, so maybe questions. So I don't know how we expected to.
Elizaveta is back here. Elizaveta is back.
Ah, okay.
Yes, I'm here. I'm trying to breathe carefully, but my microphone seems to be working. So, dear Elena, thank you so much. It is a big honor for us to develop cooperation with you, with the BRICS Law Journal. So I think if someone have a question, he or she can write it in the chat, or I don't know, or can ask. Yes, so if we do not have, I can only say it again that me and my dean Elena Titova, we are really happy that we do have collaboration, but we also have a friendship. So thank you so much, dear Elena.
I'm checking the YouTube channel here if we have any questions. Let me. Nope, no questions here.
Okay, Elena, thank you so much. And we have another amazing lady. We have another amazing editor today with us. We have Grazia, Eleonora, Vita. Dear Eleonora, thank you so much that you come here today to represent yourself and to represent the journal. We met in 2019. Yes, we met in person in the University of Bologna. It was a big honor, and I already then understood that this lady has a very, very big future. And yes, I can see her here with us, so I was right. Okay, and so this is Eleonora Grazia Vita, the editor-in-chief of the University of Bologna Law Review. She is also a Juris Doctor candidate at the University of Bologna and LLM candidate in the King's College in United Kingdom. So, dear Eleonora, please.
Hi, first of all, thank you very much, Daniel and Elizaveta, for having me today. It's a great honor for me representing the University of Bologna Review. So first things first, my name is Grazia Eleonora Vita. I'm the current editor-in-chief of the University of Bologna Review. And today I would like to introduce you all to the University of Bologna Review project. And I also have a presentation. I'm trying, okay. Can you see it? Okay, perfect. So first of all, I would like to tell you about the history of University of Bologna Law Review. It was founded in 2015 by a group of enthusiastic law students who tried to import the American tradition of law reviews and trying to associate that tradition to the European peer review culture, trying to establish and develop a new European model. We are very happy to say that nowadays Nowadays, we are one of the largest student-run law reviews in Europe, and we are very also proud to say that we tried and helped and supported other Italian universities in developing and establishing their own law reviews, such as the Trento Student Law Review. So first things first, what is the University of Bologna Law Review? The University of Bologna Law Review is a student-run, open access, double-blind peer review online journal published by the Department of Legal Studies of the University of Bologna. We are very proud to having adopted a golden open access policy, and we apply the Creative Commons attribution license, and we have a digital object index for every publication. For us, it is important to share among international scholars the culture of open access. Nowadays and recently, we have also been chosen by the Italian National Agency for the Evaluation of Universities and Research Institutes, and we have been recertified by such an institution as the first student-run law journal to be qualified for the National Academic Habilitation. To start with my presentation, our aim is being a qualified research tool for practitioners, scholars, students, legislators, and other interested in legal studies. As I mentioned earlier, some general information. So we are an online journal, an electronic journal. We have our ISSN, a DOI for every publication. But most important, we are a legal generalist law review. Therefore, our publication cover different areas of law, and we accept manuscript publication from every branch of law. And we publish online only in English. We are in co-property with the Department of Legal Studies of the University of Bologna. And in order to improve and keep up with an important scientific quality, for us it's important to have a well-structured journal. Therefore, we have different three boards: the editorial board, of course, the heart of the University of Bologna Review, an advisory board, the reviewers committee, and the honorary board. As I said earlier, we are a generalist law review, and also our essays and articles are different, since depending on the length of the article and essay, we can distinguish between article, notes, and conference paper. I will say something more about the conference paper later on. We publish twice per year, one volume that consists of 2 issues every year. Right now, we are publishing the 6th volume, and we are working on the 7th. Our author profiles are different as their manuscripts, and we publish articles from academics, professionals, institutions, and experts, of course, of legal culture. As I said earlier, the structure of the journal is really important for us. As I said, we are a student-run law journal, and our structure consists of the editor-in-chief, managing editors, and associate and visiting editors. I'm really happy to say that we have a huge visiting program, since we do not only work with students associated and affiliated with the University of Bologna alma mater, but we also work with students from universities from all over the world, not only from law school, but also from different schools. For example, we also have an editor specialized in computer engineering, since we try to improve our graphic layout skills in our publication process. As I said earlier, also we have an important advisory board. What is the advisory board for us? The advisory board is the guarantor of the scientific quality and integrity of the journal. It follows the development and oversees the implementation of the journal's scientific mission. And it's composed of several academics, authorities, and practitioners from universities and from institutions all over the world. Right now, we have more than 80 members of our advisory board, and we are really proud of them. Going on with the editorial process, which is the core function, of course, of a journal, the structure of our editorial process consists of many different steps. First of all, we accept submission from email and from the Scholastica platform. Then there is a first evaluation assessment made by the editor-in-chief and the managing board, along with the responsible of the reviewers committee. Later on, of course, if the manuscript is considered eligible, of course, there is the double-blind peer review. Therefore, nor the author nor the reviewer know the identity of each other. And the double-blind peer review consists of two steps: the over-evaluation judgment and the complete review. After that, once a manuscript is considered publishable, there is the editorial process carried on by students. There is the sources and translation step, the copy editing steps, the proofreading, and the graphic layout activity. What distinguishes a University of Bologna review from the others journal is the Blue Book, the system of legal quotation used. As I said before, earlier, we tried to import the American tradition of law review. Therefore, we chose to use the Blue Book as a system of legal quotation, which is one of the most important legal quotation systems used in the US by the Columbia, Yale, Harvard, and University of Pennsylvania universities. Since there are many rules, of course, this is a really huge legal quotation system. Our editors are divided depending on the group of rules of each team. And so each team of copy editors handle and manage different rules. And every group is supervised by a managing editor, as I said earlier. So once the copy editing activity is done, of course, there is the digital and the publication. First, as I said earlier, it's important for us the graphic layout activity, which is made according to our own syllabus. And we also are really happy to say that we use markup languages such as LaTeX in order to improve the quality of our publications. And we are supported and helped in the publication process by Alma Digital, which is the specific part of our Department of Legal Studies, which supports us in this process. And then, of course, there is the digital storage. And now I can say that we are very happy to say that nowadays, we are indexed in very different databases: Google Scholar, SSRN, Doagi, and lately we have also been admitted in Scopus and Web of Science. Therefore, for us, it's very important to keep up with the scientific quality of our manuscripts. For me, it's important to tell you about the structure of our editorial board, since we are here to understand how law reviews, our online journals, can become an important and preeminent tool for legal knowledge and for legal scholars. Therefore, we do not have only copy editing editors, but we also have editors specialized in every different aspect, such as social media, recruiting and events, promotion, human resources, and welfare. This is very important because these groups try to create new opportunities for editor to make us known to the public, organizing events such as the Symposium. The Symposium is an event that we organize every year. It's a kind of Lectio Magistralis held by a professor, an academic chosen by us. We're very happy to say that last year we hosted Professor Floridi from the University of Oxford. And it is very important for us because every year from the Lectio Magistralis, we extract the conference paper. As I told you earlier, it's one of the kind of types of essays that is published then in our issues and then in our, of course, volume. Social media, of course, it's one of the things most important because it's important for us in order to share our publication. And once we share publication, of course, we we hope and we try to make us indexed and cited and quoted by more and more authors. They're creating an events group because for us, as I said before, it's really important to find motivated and editors, both from our university and from all over the world. I'm really happy to say that we try to develop new possibilities and new opportunities for our editors. That's why I was very happy to share with our editors the possibility to join the university Candido Mendes, the South Ural State University and Umbria University in the project on low digital technologies and ADR, in order to give to the editors the possibility to find new international and comparative perspectives. And that's why we are very happy to be partner of this project and to be here today, because for us is very important to find new realities and new entities that, like us, wants to spread legal culture all over the world and try to keep up with the scientific quality. So thank you very much for your attention, and of course check out our social media for our, of course, call for editors, in particular if people are interested in becoming visiting editors, and of course to check out our call for papers, since of course we are always looking twice per year for new manuscript to be published in our journal. Thank you very much.
Eleonora, just a quick Brazilian joke. I heard that to publish at the Bologna Law Review, you need to climb all the way up the Asinelli Tower in Bologna. Is that true?
You can do it only once you're graduated, but once you're graduated, you can do it.
I went all the way up. It was tiring. Lovely city, Bologna, lovely city. First university in the world, so yes. Always a good way to visit. Yeah, alma mater.
Hey, dear Eleonora, thank you so much for being with us. So as far as I understand, we do not have any questions, right? Yes. So thank you again. And we have amazing speakers with us today. So, and I want to introduce you to Professor Lynn. He's the Dean and the Professor from the Dublin City University, Ireland. So he's also an expert in the digital technologies, and he teaches courses in data science, in strategy, and in digital marketing. Dear Professor Lynn, thank you so much that you are with us today, and we are eager to listen to your keynote.
Okay, thank you very much. Let me just load this up here. Firstly, thank you for inviting me. I'm a big fan of Brazil. We have a lab in Recife, and I publish regularly with Brazilian colleagues, so I'm delighted to be here, and I'll be in Brazil in February, so hopefully we'll get to meet Daniel. I suppose my background is I have taught law, so I have a PhD in law. I'm that worst type of law student, which is in corporate finance law, so the most hated of all lawyers. And I spent 15 years as an entrepreneur, setting up software companies, and I sold those software companies to one of Bologna's competitors, the University of Cambridge. But I have always remained in contact with the law, and then I transitioned to academia 10 or 12 years ago. So now I'm getting old, so listening to all these collaborations is very exciting. So I thought today, Elizaveta asked me to talk about some ideas that I had in the context of digital technologies and law. And I suppose from my perspective, I ran the National Centre for Cloud Computing in Ireland for 10 years, and I sit on the kind of the intersection of business law and computer science. So I'm quite interested in how all these things come together. And I think whether you're a law professor or a lawyer, future lawyer, student, I think digital technologies have a very important and impactful way on what your career will be like over the next 15 to 20 years. And I think that this is a very interesting conference in that context. And what I wanted to talk about is the metaverse, because obviously in the last 2 weeks, Facebook in particular has decided that they would reposition themselves in that particular domain. And it's an area that I've been engaged with since around 2006. And I thought what would be interesting would be just to revisit what the metaverse is and just talk about what are the implications of the metaverse. And maybe there's some ideas there and some topics that we might explore further in collaborations, etc. So I come with a warning. I feel like I've brought a knife to a gunfight because obviously I don't teach law on a regular basis, but I come from a corporate finance one, so I'm not so sure all my legal comments will be as up to date. But also it's an international audience, so you know I'm sitting here in Greece, and we've got European Union law, there's national law, in Brazil you have different laws, Russia different laws, etc. So I'll try and keep this as wide as possible and as general as possible. And the other aspect of this is the future fallacy, that you know when you make any kind of comment about the future, there's a fallacy because you don't know what the future is going to happen. And so I started looking at this 15 years ago, and now Mark Zuckerberg's come out and he said, oh, the metaverse is here, and we're going to, and whether that's true or not, I don't know. And I always hark back to, and these are postcards that were designed in 1899 by a French artist. And he was commissioned to look at, well, what would the world look like in 2000? And so here's his pictures. And the first picture here is how he viewed the law. So he saw, oh, lawyers would talk to clients via some kind of gramophone. And in one sense, Cote predicts the future. So we have many of these things. We have automated agriculture, and we have microscopes. That's the second thing. We have Roombas, robots to clean our floors, but he didn't really get the detail on place. I mean, even in the education context, this is how he saw that we'd all be learning. And I suppose it's more the matrix than what we have today, but you know, that's the future. And the future doesn't necessarily come to fruition. But what we know about the metaverse is that we have this context right now. And it's a context that you're going to see increasingly discussed. And it's a form of extended reality. So what we can say is that there's an interaction between a digital world and the real world. And we can describe the metaverse in terms of immersiveness. And if you go out and try and find a definition, you'll find that very difficult. You'll find definitions of virtual worlds and augmented reality. But what we're talking about is some increasing degree of immersiveness from the physical world, which we have rules in, to a virtual world that's completely digital. And so in between there, we have this idea of augmented reality and mixed reality. And indeed, Dublin City University, where I'm based, is the first, I think it's the first university, certainly in Europe, but possibly the world, that has a fully mixed reality classroom. So we actually have a classroom that's built specifically for mixed reality experiences. So what does that all mean? Well, we can describe the metaverse by its characteristics. So we know, first of all, it's facilitated by a global distributed network of computing devices. So you're wearing a device, cloud computing is a very central part of that. And that has implications, which we'll talk about later, but primarily it has the implication is that activities occur in a distributed way around the world. And we may not be able to identify where a particular activity occurs or where someone is based. And that an anonymity of infrastructure, but also the control of infrastructure, has an important legal implication. It has multiple independent users. So the metaverse it can be used by yourself, but it has multiple users typically on scale. And it's embodied, and you'll see that Mark Zuckerberg and Facebook will talk about this idea of the embodied internet, in that you have an identity in this virtual world, which may be different than your identity in the real world. And that's an important aspect, because central to much of our laws is the idea that we can identify a party to a particular activity or event or contract. And it's a social space. So you cannot have a metaverse without some way of interacting with the metaverse and with other users of the metaverse. It's simulated in the context that there is a world and it is parallel to our physical reality. And because it's simulated, it has rules. And those rules have loopholes in much the same way that we have loopholes in how society works today. So in different contexts, there's different types of rules. And the most important thing, I think, in terms of distinguishing it from bulletin boards or other kind of discussion groups or 2D discussion groups on the internet, is the idea that it's persistent. So even when you're not logged in and using your avatar in a virtual world, that world persists. So in this particular context, I think it's Minecraft, vegetables and crops continue to grow and things age. People will continue interacting and changing the environment even though you're not in that. And that has implications for legal aspects. And it's interactive. So a couple of things is that pretty much all the different types of activities we can do in the real world, and then some of the activities, new activities, can be done in this virtual world. And because of that, many of the same legal implications arise, but how we handle them might be very different. Okay. I'm saying this, I realize I've been given 20 minutes to do a fairly complex discussion, so this is very high level. So here are just some superficial observations really on legal implications and phenomena in the context of the metaverse. So first of all, we have this idea of identity. So here's Mark Zuckerberg, the CEO of Facebook, and here's his virtual avatar for Halloween. And when we think about identity, there's a couple of interesting things. First of all, your identity in a digital world is not necessarily the same as your identity in the real world. So for example, you can be completely anonymous. You can look totally different. You can change nearly everything about you, that aspect of you. But equally, because that is different, and you can change your name and your behavior and your characteristics, it introduces significant legal problems. For example, if we take the context of defamation, right? The basis of defamation law is that I can identify the person that has been defamed, okay? And that the statement is of and concerning that person. So does defamation law, is it defamation if I defame, one virtual user defames a digital identity of a real person, although that digital identity doesn't have the same name, the same characteristics, the same behavior as that real person? So can someone defame my digital self? And that's a very complex question, because first of all, if the person's anonymous and using a different name and different style, different look, you can't actually say you're defaming that person in the real world. But the second thing is, if you establish on a basis that someone's digital representation in these virtual worlds is a piece of property belongs to them, can you defame the property of someone? And that's a very different legal basis. So when we talk about these things about identity and defamation of identity, that becomes very, very complex suddenly, okay? What happens if someone steals your identity? So I'm looking at all these lovely ladies. I have Elena and I have Elizaveta, Daniel's there, and they look great. So this is what's called the Copybot Controversy. So in 2007, a company released a piece of software called Copybot, and literally it could copy all aspects of your identity or any artifact that was in Second Life. And therefore, if you had something valuable, it could just copy it, and they had their own version. So it actually totally degraded the value of an object in Second Life. But this has got to the point now where deep fake technology, I can literally create my own version of someone else and pretend to be them in this virtual world. And so am I, have I now, do I own the rights to that identity in that virtual world because I've chosen to look like them? maybe I'm Daniel's long lost twin in the metaverse, and he might be happy with that, or he might be very unhappy with that. And so what rights does Daniel have that? And so when we look at legal cases in this context, it's not particularly helpful. So for instance, there's been a couple of cases primarily around the entertainment industry in the US, Aguilar versus Universal City Studios and Doe versus TCI Cablevision. And what they found is similarity is not sufficient. So you can't establish sufficient ground just because, well, that looks like me and they're using a similar name to me, but you can't establish that they're actually stealing your identity, okay? On the other hand, there are situations where people do steal identities. So Habbo Hotel was a very popular Finnish virtual world, and a number of Dutch teenagers were arrested for stealing virtual furniture. So I want to put this in the context. They went into another teenager's room in a virtual hotel. They stole the furniture from that room, put it in their own room, okay? And they were reported to the Dutch police for stealing furniture. Now, ultimately, the police said, well, we're not charging you for theft in the first instances. In the first instance, we're going to charge you for identity theft, because you went in and somehow you were able to impersonate this person to get access to their room, and then you stole this virtual furniture. Just to put it into context, they stole about 5,000 euros worth of virtual furniture. So it's very important to understand this furniture has a value in this game, and they stole it. But it has a real consequence. So this digital furniture actually probably cost more than the real furniture would have cost. I don't know that many teenagers that have 5,000 euros worth of furniture in their room. Okay, so there's an instance. In the second instance, because we're talking about ownership, and if we deal with it as property, this character here with the wings is called is Preen, and Preen was a character in Second Life who would meet you occasionally and give you wings, and it turned into a very popular thing. And the designer of that character, Amy Weber, got the first US copyright in a virtual world identity. And that was in 2007, 2008. And what's interesting about that context is, traditionally, to get that copyright, you would have to embody it in something physical, but it only existed in a virtual context. Now, there's a flaw in the thinking here, because they gave a copyright to this brand per se, but in fact, obviously, the difficulty is in reality that brand Preen is an interactive element in Second Life, whereas the protection is only for the static version of it. So there's all this difficulty about, well, what does it mean to copyright something in a virtual world? And obviously virtual worlds, because of the social aspects of it, can result in physical hurt in the real world. So things like cyberbullying, etc., laws relating to that, harassment, etc., still exist in the context of virtual worlds. And in fact, one of the first philosophical papers about the law and virtual worlds dealt with the idea of cyber rape in a text context. And it was found actually, well, it's not the same because it doesn't physically happen, but psychologically, it has a scarring effect. And so this idea of, well, what happens when people gang up on a virtual identity, particularly where, if, say, for instance, someone spends more time in their virtual world than the physical world, okay, which has happened just, do they believe that their primary identity is associated with their virtual identity as opposed to their real world identity? And in some instances, what we've seen, and particularly in Asia with otaku culture, there's been instances where parents have spent so much time addicted to online behavior and online activity. They've spent up to 3 days online at a time. And having not fed their children, those babies have died, or that they have died because they failed to feed themselves, etc. So it has very real consequences for themselves, and there's an addictive behavior. And the designers of these virtual worlds build an addictive behavior into these things. And so there's all kinds of social dilemmas there, but there's also this idea is, if you are bullied in a virtual world, is that the equivalent of being bullied in the real world? And actually, the courts have found that in some instances, well, it's not as severe, but psychologically it may be. For instance, there's a case here. This is Maple's story. It was a Japanese scenario where a 43-year-old lady was divorced from her husband. Her response, in a weird kind of revenge, was to kill off his online persona. And this was a cause of their divorce because he spent so much time playing in this virtual world that she was upset. They got divorced. She was very angry. The courts found that she committed a virtual murder, that she had deleted this person, and she faced I think it was, I can't remember, it was a $5,000 fine and 5 years in prison for this act. The most famous case, and similar to this, is what's called the Legends of Mir case, where, which is very complex, but it comes down to this. A player spent a lot of money to acquire a special type of sword, a dragon saber sword. It was stolen by one of his friends. He then sold the sword to another player for the equivalent of 7,000 renminbi, which is about 480 pounds, so about 600 euros. The original owner went to the police. They said, we can't do anything about this. So he then went and murdered the thief of his sword. So now what we have is a virtual theft. We have the sale of the virtual object. We have a report of a virtual crime, and then we actually have a real crime and murder resulting from that virtual crime. And this whole area is full of little loopholes. So for instance, in this particular case, was a company, BSI Interactive, who found loopholes in Dark Age Camelot. And what they were able to do is build software, and they hired like a sweatshop of workers in Asia. And what they used to do was they would generate and acquire lots of swords and various weapons and artifacts. And then they would sell those artifacts off-site to other people. And they got sued, and their account got deleted. And then they sued the original manufacturer, saying, look, you know, we did nothing wrong. We just used the game. And they said, well, no, it was against the spirit of the game. And the court said, well, no, nothing stopped these people from playing in that kind of particular way. So it raised a very interesting IP issue. This is Roblox. If you have a 10 to 14-year-old teenager in your house during COVID, you probably know about this. Roblox is a platform, about 14 million users, where people can build their own video games. And basically you can charge people to play your video games. You make lots of money. And just, you know, it's created a number of 12-year-old millionaires who build these video games. And an interesting question is arising in the courts right now is, who owns the video games? Does the video game belong to the person who creates it, or the platform that enables the creation? Because there's an interaction between the user who can use the tools in the platform to build something and the owner of that. And interesting, it relates to that is the idea of metadata. So who owns the metadata about how that's used? So who owns all the customers for the games that are through Roblox? And this is interesting in the context of the Facebook Metaverse vision, because obviously famously Facebook has said that they owned our photos when we uploaded them onto Facebook. So one would imagine that they're thinking very carefully about, well, if people build new worlds in our metaverse, who owns that? So this whole area of intellectual property is really, really important. And it goes back to this idea of distributed computing, because understanding which jurisdiction will apply in this context is also important. Is it the jurisdiction where the creator is, where the platform is registered, where the activity happens in the cloud, which is very hard to determine of. So there's a whole variety of aspects around the issue of IP ownership. And metadata is only part of that, because imagine you live in a house and you own that house. Somewhere in nice Rio. I have my lovely apartment looking out onto the Sugarloaf in Rio, and suddenly someone comes along and creates a digital twin of that building, but decides they want a bit more space. So now that you find that there's someone who lives in a digital twin of Rio with your address and your building and your house, only they've expanded it and they've made it look really nice, but they have the same address as you. Do you have rights in that digital twin of your building, of your property? And so that's a complex area. And property is a very, very important aspect of virtual worlds, because from the very beginning was the idea that you could buy lots of land in virtual worlds. So land law becomes an issue. So this is the case, in this particular case, it's Bragg versus Linden Labs, or Linden Research. And interestingly enough, Bragg was an attorney, and he was very into Second Life, and he decided that just land on Second Life was sold in auctions. And he just decided, I'm going to buy up loads of land in Second Life. So he bought up all this land. And the owners of Second Life said, no, you shouldn't be allowed to buy up all this valuable property. And so they canceled his account, okay, after he paid them and everything like that. And he brought them to court. And interesting for Daniel, there's an arbitration story in this. Brought them to court. The Linden Research said, well, we tried to implement arbitration, but he insisted on going to court. And the court found two things. First of all, it was a legal purchase of land. So he bought this land, he was entitled to it. But the second thing was, even though there was an arbitration clause, it was insufficient to settle the matter, and it was biased towards the platform. And so it failed in that, and in this case, the plaintiff got access to his land. So there's an interesting thing here, though, is that we have this land, but there's also, it makes an implication about the importance of the contract between the user, the player, and the owner of a virtual world. And sorry, I'll just come to it. It's comprised of three things. There's a term of service, a service level agreement. Typically, there's an acceptable use policy. And so what you have is this very centralized idea of a company saying, this is what acceptable use is, and we can change that anytime we want. And what the courts are increasingly doing is saying, no, that shouldn't really be the case. If someone buys property and to use it in this context, you can't just change the rules around that. And that's where I think we'll see things like NFTs, etc., coming in. I'm going to talk about that in a while. One of the last areas I just want to talk about around activities is this idea that we will be working in the metaverse. Obviously, right now, we're kind of working in the metaverse. And working in the metaverse is also very interesting because it's a bit like crowd working, because there is a suspicion that metaverse type work may result in a dilution of employment law and your rights. Because one can imagine that you can be working in the metaverse and a company can select the most advantageous employment regime to suit them. And therefore, it impacts your rights as an individual, your minimum wage, etc. And so one of the problems here is it could be difficult to decide where is someone performing the work? Is the place of work wherever the metaverse is located, or is it where the company who supplies the metaverse, or is it the employer? So there's a whole variety of aspects there that we need to think through. Non-fungible tokens are an interesting area because they've been recently presented as a separate technology innovation, mostly around the art world. And one of the areas in the metaverse that it may have value is in this context where, unlike the case where we had Bragg versus Linden Research, and there was a centralized owner of the virtual world, an NFT might be a solution for land sales. So I want to sell a piece of land in a virtual world. I can actually embody that as an NFT. And therefore, I can transfer that value to someone. And so this particular universe is a new product, and it begins with D, and I've forgotten the name of it. I think it's like Dreamland. And one of their aspects is that they're, when you buy property through their platform, you're given an NFT, and therefore it's not centralized ownership. It's a decentralized ownership as part of a blockchain. Now that provides a whole variety of different types of issues, because what if I decide to turn off the virtual world? Does my NFT lose its value? Part of the NFT logic is the code is law. You know, that if we have this code, you know, we can enact that. And that's very much based around this idea of Daniel Lessig had. But if code was law, everything would be settled and we wouldn't be having this presentation or conversation at all. And the reality is these conditional statements, if this, then that, are not human related. You know, I mean, humans are dirty and complex and messy, and we always find some way of messing things up. And computers are really good at executing conditional statements fast, but then they get into awful trouble when there's slight variations. And, you know, it's like a shift back to the 16th century and thinking about casuistry and the Jesuits and trying to define what the line is in these things. So it's not clear to me that code is enough, right? Now, if we don't think code is enough, the answer to that then is artificial intelligence. And so what we've seen is that in these cases, particularly in China now, they've introduced this idea of an AI-based court. And that for very specific types of scenarios, you can have this adjudication. And in the context of AI, of course, our concern is always that AI of sufficient complexity tends to be pathological. So it can go off in its own way, like the Matrix. And then on another side, it tends to be lack transparency. So while it has a lot of benefits, it also has a lot of drawbacks. And so the goals of artificial intelligence are very different than the goals of society or legal context. You know, in AI, we want either systems that think rationally, systems that act rationally, or, and this is a very different philosophical basis, systems that think like humans and systems that act like humans. Humans are not rational. As Kahneman would say, we're post-rational. You know, we're emotional beings, and then after the fact, we rationalize what happened. Okay, and that's why we need judges and a legal system. But what it might be more worrying is a trend where we go thinking that, well, do we want AI that think like legal professionals, whether that's a lawyer or a judge or a designer of a system, or AI that act like legal professionals? And that's a very, very different thing. And so what would that test be? And obviously that test is a contingency theory. It would be a test that we'd have to set out for different legal jurisdictions. I want to just finish on just one thought about what the implication is maybe for younger lawyers. I think that when you take the metaverse, or you take NFT, or you take artificial intelligence, or any of these things, what it points to is a change in how we need to conceptualize legal education. When I studied law, I did undergrad and then I did my PhD. PhDs in law are a rare beast, but you know, first of all, legal education is often a solo endeavor. You know, in Ireland, for instance, a barrister, someone who tries a case in court, by definition can't enter into partnerships or into a company. So they're always by themselves. So they're like a lone businessman or entrepreneur. And then solicitors can create firms. But the reality is we do very little education outside of the law in law school because there's so much to cover. You know, there's so much to cover, and it's an increasing amount of context. And increasingly in the digital space, lawyers need a whole variety of different types of skills. So, you know, I'm a firm believer in the idea that we need multidisciplinary and interdisciplinary legal experts. And that requires us spending and finding the space in law degrees to develop lawyers, not just as a knowledge expert, but as a data scientist, as someone who trains AI for legal systems, as someone who monitors those systems, someone who researches how those systems could be used, but also making decision-making and creating those tools. So I suppose my end message is a lot of uncertainty ahead. It's probably a very good time to be doing research in this area, because, you know, in 2006, it was probably, you know what, a bit too far away. Right now, it's probably a bit too hot, or, you know, but in the coming years, it's probably going to be about just right. But I would say to this, at the moment, I can't find a lot of evidence that there is something new here that hasn't changed since 2006, 2007. So I think that we do have some precedent, some thinking that we can draw upon, right? So what was happening in 2007 seems very similar to 2021. But what I would say is whether our legal thinking on this context is developed, I'm not so sure. I think we had a big spurt of activity mid 2000s, and then we kind of left it alone. But what I am sure is this area will be full of problems in years to come, and it means good work for those lawyers and law students who are interested and qualified to deal with it. Thank you very much for letting me talk today and ramble on. I hope you have a really good conference. Delighted to see so many different nationalities involved, and thank you very much.
Thank you so much for this brilliant keynote. I specifically liked all the pictures. Thank you for this too. And your keynote reminded me of, I think everyone is familiar with the Big Bang Theory and with the episode when someone stole the Sheldon Battle ostrich. Yes, so the virtual game property was stolen, and the police officer said, but the jurisdiction of the Pasadena police doesn't spread to your virtual game. So yes, it is a really big issue nowadays. Thank you so much. And we also have some questions in the chat.
Elizaveta, I'm a gamer here, so I love your presentation.
I'll do my anime presentation next time for all my Brazilian friends.
Yeah, no, I'm a gamer. My brother, he plays Final Fantasy forever. I play FIFA soccer. I love FIFA soccer. And I'm a soccer fan. I'm Brazilian, so I'm a gamer here. And it's funny that you mentioned the Second Life case, and the curious thing about the decision. Because there was an arbitration agreement in the game, and the guy who had his account blocked, he actually sued in Pennsylvania state, and Pennsylvania considered the theory of minimum contact because he had contact with the owner of the company inside the virtual world. So in Brazil, just so you have an idea, state jurisprudence is considering if you have your account blocked or erased or something, or deleted from the game for violation of the ethical code or something. If it was a mistake from the game, they consider that you have moral damage for that because your avatar is attached to your identity, so to your fundamental rights. So that's kind of, in Brazil, they're already deciding that your avatar is part of your identity, like your phone, cell phone number or something like that. So it's getting bigger and bigger.
The data protection issues in this are massive. I mean, just think about this. When you die in reality and your avatar persists in a digital world, okay, what happens? Does ownership revert to the platform? Does it get bequeathed to your heirs? So what happens to your legacy data and your metadata that was maybe created with the platform? If the platform gets sold, where are your rights? So there's a whole variety of these things. In the context of even in the arbitration case there with Bragg and Linden, even when you look at terms of service and acceptable use policies in these, what you're going to find is a whole variety of issues which are designed to scare people from taking any action against those companies because they're heavily loaded towards the platform. And we've seen that in cloud computing, we've seen it in social media. And that will be the case here. So it's a very rich area for any kind of legal research. Do you know what I mean? It doesn't matter. But I think, Daniel, you point out an incredibly important part. When we think about this in terms of international law, it's a minefield, you know, and so it becomes this kind of very rich area, both for the design of legal strategies for corporations, but also from a consumer perspective of what does it mean to be protected as a consumer.
For
Obviously,
example,
in the context of Europe, sorry.
The biggest virtual world is World of Warcraft. At least it was last year.
It's terrible. I know some of it's based in Ireland, so we're really happy about that. But
yeah,
but to
but
put
I
it
don't,
into context, World
I
of
don't know
Warcraft.
if we have an office here in Brazil. So how can we sue it? For example, you know, that's kind of crazy.
Interesting enough, if you take World of Warcraft, just to put it into context, auction revenues in a given day in 2014 for World of Warcraft were 10 times the revenue or the transaction value of eBay. Okay, so part of the difficulty here is that people do not have a conceptualization of how large the economic value that's being transferred in a lot of these things are. So we talk about Roblox, where most people aren't that aware of Roblox, yet it's, you know, it's IPOing for $1 billion, you know what I mean? It's creating 10-year-old millionaires around the world. And so these virtual artifacts, which do not have agency, right? Now the avatars have agency. So the complexity here is very different than the real world. You have digital avatars that have agency, and you have artifacts that have no agency. And the difficulty is there's economic value being created, but with the wave of a wand, that value can disappear as well. And so there's massive philosophical, legal, moral challenges about this. But just to answer one question you raised there about GDPR and data protection, the interesting thing about the GDPR in Europe is obviously it's extraterritorial. So if World of Warcraft, so Blizzard, have data on a user from the European Union, that user then has rights to sue outside of Europe. So they have rights independent of the location of the company. So GDPR is particularly interesting because it's one of the first extraterritorial, large-scale regulations that's put in place. So it has massive implications for non-European companies that interact with a European citizen. And that European citizen does not necessarily have to be in the European Union. They just have to have a European passport. And if they interact with your platform outside of Europe, they have rights. And the EU.
Luckily, I'm Portuguese too, so I have rights.
Yeah. Oh, sorry. Are there any other questions there? Sorry. Oh my God, NFTs and value. Well, I think that we have a massive debate on understanding how value is created and embodied in NFT, and whether it's just value because we have a shared concept that something is valuable. So NFTs, for me, I think they have some interesting applications. So a very good one would be our degrees. I don't know about Daniel and Elizaveta in your colleges, but you know, you go for a job in the university and they say, oh, we want your transcript of your degree. And you go around and you're trying to find out, it's all a nice picture and you have to get it certified and bring it in, or you have to go to college. So for instance, NFTs can be very useful in the context of embodying a very specific type of document or an artifact like that. So today, I do some research in the dark web, and I found out that the hottest thing to buy in the dark web right now is an Irish COVID-19 vaccination certificate. So you can buy apparently that on the dark web. And so now the Irish government is looking at, okay, now we have to think about how do we make that immutable in such a way that we cannot copy something. So NFTs allow something to be immutable, allow someone to embody that. But over time, I think what we're going to have is some kind of global registration of NFTs and who owns those NFTs. Otherwise, what happens is over time, you find that someone always comes up with a way of duplicating things. So NFTs to me seem that we need, and in the context of virtual worlds, to me, it seems that at some point in time, like we have with URLs for websites, we will need some kind of global system for managing rights in NFTs, independent of the blockchain. Because blockchain, by definition, is trustless, but it's not without vulnerabilities. So I'm not quite. I think it's interesting, but I think it requires a lot more thinking out. I mean, at the moment, we're still playing with NFTs. Well, there's lots of questions here. Right. So I think that's okay. Do I have to do any more here? It's all just NFTs. Any other questions other than NFTs?
I think there's one right above.
Me.
Do you believe that the return that's the NFT also from Bernardo? Bernardo's a student of mine. Both are NFTs. Yeah, that's the same question.
I find myself, anything to do with blockchain, I inevitably end up thinking Ponzi scheme. And I have yet to be proven wrong on this. So for all the promise of blockchain, and I've been researching this for like 8 years, I still haven't found a sustainable business that someone's driven around blockchain that isn't selling blockchain services to someone, or Bitcoin, which, you know, even in the context of the most famous side of Bitcoin, we take something like Coinbase. I mean, their stock has dropped dramatically this quarter on the basis that people just moved the coins around the place. I do think if you're interested in NFT, the area which is not related to virtual worlds that's quite interesting is security tokenization, where you're looking at regulated tokens, financial tokens. So instead of a Bitcoin, which is unregulated, you're looking at doing secure token offerings. So like an IPO based on Bitcoin, but it's on a hybrid model. We've seen some very interesting models arising out of the US around that. I think if you're into corporate finance, that's a very interesting area. But for the love of God, that's your interest in corporate finance is Bitcoin and stuff like that, you probably need to stop studying law. So I think that blockchain and Bitcoin, you literally do need a qualification in philosophy to understand it. And I think that it's a very deep hole to get buried into. But I do think NFTs might have some solutions. So I'm wondering. Elizaveta, take over control of the Zoom and pass it to someone else. Oh.
Okay, thank you so much, Professor Lynn, for your brilliant keynote, for answering the question and for being with us today. So we do not have any question. Yes, so thank you so much. And we have another amazing guest of honor. I want to introduce you to Professor Migle Laukyte. Migle, hi.
Hello, can you hear me?
Yes, I can hear you. Migle Laukyte is a professor from the University of Pompeu Fabra, from Barcelona, Spain. She conducts research in the sphere of artificial intelligence. And we met 2 weeks ago, right, dear Migle? It was the workshop on artificial intelligence and human rights. And Migle presented highly interesting keynotes. And that is why we decided to invite her to share her research experience in the sphere of artificial intelligence. Thank you, dear Migle, for being with us today. Please, the floor is yours.
Can you hear me, right? You
Yes.
can hear me.
Yes.
Okay, good. Yes, I can hear you. Thank you, first of all, Elizaveta, for your invitation. It was very nice of you to invite me. Actually, it's an honor. It's a great honor to be here to listen to all of you. Unfortunately, I will have to leave at 2 p.m. So I'm really sorry that my talk will be quick, and I also know that the time slot foreseen for our talks is until 2 o'clock, and there is still Professor Ferrari waiting for her turn. So I'll try to get to the point immediately and make it quick and painless, hopefully. And I also, I want to add another thing is that, Elizaveta, I really thanks a lot. And I think your enthusiasm is something that you're, so to say, spread around you. And I think that's a really nice quality for an academic. And I hope your students feel that and share it with you. Okay, so I will share my screen, and these satanic tools of interaction that we were forced by pandemics to share hopefully will work. Can you see my screen?
Yes.
Okay, good. Okay, so my talk is on artificial intelligence and analytics on dilemmas for justice, employment, and human rights. Actually, it was a topic that I dealt with in the conference that Elizaveta has mentioned already. And it's kind of complicated topic, but I think there's a lot of things that are going on in artificial intelligence that we should care about. And we should, so to say, try to deal with maybe, I think as usual, we're looking at the United States and see what's happening over there. And afterwards, we somehow look at these changes and at these developments through the lens of European law and see how these changes could impact us. And my presentation is basically about that. So how the analytics applied to the courts and could actually be seen in Europe, and what threats they give rise to in terms of human rights, in terms of justice, in terms of employment. So I actually don't know whether you're familiar with court analytics and judge analytics in particular. So basically, when we speak about the court analytics, we speak about the algorithmic systems that analyze the work, the cases, so to say, so as to extract useful information, right? In a particular jurisdiction. So the algorithms can actually analyze the data of the cases, the parties, the party legal history, so whether they are successful in the cases that they present to the courts, whether they are less successful, what kind of cases they usually present, what they are debating usually about, and things like that. And within this great realm of court analytics, there is also a particular part of it that I'm focusing on is what is called judge analytics, right? So rather than looking at the cases, the idea is to look at the judge and try to understand how he or she works, right? What kind of tendencies he or she has, whether he or she is quick or not, what kind of cases he or she usually is favorable to or less favorable, what kind of arguments he or she is more attentive to, and many more things. On your screens, you can see one of these systems. So it's actually to learn more about your judge. And in this case, we can learn quite a lot about Consuelo Marshall, the judge in the District Court of Central California in Los Angeles. And on the right side, you can see a lot of data that we can see about her, the curriculum, her positions, even her phone, work phone, of course. And all the more details. So basically here you can see the ruling tendencies, top 5 defendant filed motions, the speed, time to rule, average days to rule, and many more information. You can also compare the judges. thanks to these systems, which of course are not for free, they're for payment. So actually this is a new field where huge amount of data has been, well, so to say, put to produce profit. Here, there is also a possibility to compare different judges. So here, just a few of them. And you can see, well, different ratings so that you as a party could decide whether a certain judge that was assigned to you could be actually would mean that your case will be how it might, most probably it will be dealt with. And also you can see what your judge has been citing in his or her cases. Again, we are in the United States, so we are referring to the precedents. And basically, well, you can also see what is awaiting you on the basis of the previous cases that a particular judge is relying on. So this is what the data can provide you with, right? In the age of well, big data, right? In terms of judicial proceedings, there is a lot of information that can be extracted and a lot of uses that this information could be put to. So this is what actually my talk is all about, right? Whether this information, these kind of applications and these kind of, well, possibilities offered to the parties are actually, well, is it all fine or not? So in particular, let me reduce this, okay. So in particular, judge analytics basically helps to detect certain patterns of behavior, right? How he or she thinks, how he or she acts in certain cases. Compare the judges, and for the parties, it means that they can elaborate a strategy, right? Because when you know what kind of judge you will have in your case, then you can also act accordingly. And you can also, these systems predict the outcomes on the basis of these strategies. The big question is whether this judge analytics is a good or bad thing, right? On the one hand, yes, it looks quite good, right? It turns our court systems into more transparent ones and more accessible, right? But on the other hand, my question is whether this exposure is really without a price, right? Whether the transparency and accessibility is the only outcome that these systems produce, and whether there are any risks to impair the autonomy and partiality of judges, and, well, the due process as such as well, whether it is under any sort of threat or no. We have also a French case in Europe, a quite famous ban on judge analytics, which was basically caused by the scandal of Benesti research. Professor Benesti has discovered that, well, in the same court, the same kinds of cases were judged very differently, although the circumstances were the same. And this research was actually was focusing on immigration, right? On people who were seeking asylum and presenting their documents to get this permission to stay in France. Basically, although all the requests were more or less the same, the judges have decided very differently. And basically, what the message that reached the society was that it's not question whether you qualify or you do not qualify for a permission to stay in France, but it's a question of luck. So who will judge your case? Because it's not about the law, it's not about the rules, but it's about the person who takes a decision. Of course, the society did not react positively to this news. It was a huge outcry saying, well, what the hell is going on, right? A French legislator took quite a strong position on this, and basically said, well, I do prohibit any sort of use of identity data of judges. for any kind of purpose that we could put under the umbrella of analytics, right? So no evaluation, no analysis, no comparisons, no predictions. So the judge should not be used for data analytics. And if you decide to do that, the sanction is 5 years of prison as well. We can see that the reaction of French legislator is quite strong, right? Five years of prison is well, I think quite a lot. And actually, so the huge question is whether it is a solution for what Benesti's research has discovered, right? Is it really what has to be done, right? If we discover, thanks to the predictive algorithms, that immigrant rights human rights are actually are violated, and also violated by people who are at the top right of the society hierarchies. So is it the solution? Is the solution to ban these algorithms the right one, and whether this is how it should be dealt with? There is, of course, a role that GDPR, that has already been mentioned, General Data Protection Regulation, the role that GDPR is playing in this discussion. Because on the other hand, if we actually look at it from the judge's perspective, we find ourselves in front of a sort of a profiling, right? Data analytics lead to the profiling that we understand as a form of automated processing of personal data, consisting of use of this data to evaluate certain personal aspects, and in particular, to analyze and predict aspects concerning that natural person's performance at work. So judge, as an employee as a state official, right, is being profiled. And when such profiling could have legal effects concerning this person, then the judge, at least theoretically, has a right to oppose, right? But such profiling can be legal if the member states permit such practice and ensure that the safeguards are in place, and if the judges actually give the consent. The question is whether a judge could give a consent. I've talked to different judges, and there are, well, different opinions. On the one hand, some of them say, well, I'm not a data object, right? I'm not here to produce data. I do my work, and I don't want to be over-analyzed, right? And I do not want some sort of algorithm to tell me how I work, right? Because another question that is, I think, very, very important for all of us is that we do not question algorithms. We take for granted that they are right, although they are more often than not, they might not be so right, right? But on the other hand, there are also judges who are saying, well, I'm curious to know what it would say about my work, and I want to see whether I'm doing something wrong and whether I can improve my work. So the positions are very different, right? So as to the giving consent to this kind of profiling, we're still kind of, the positions are very, very different. And if we also have to bear in mind another perspective on data analytics is that it does not necessarily have to stop within the realm of justice, right? Within the realm of courts. These kind of systems could be quite easily transferred to other domains. They can be transferred to medicine. They can be transferred to education. So if you think about us as university professors, our work as well could be evaluated in the same way, right? So on the one hand, if we were evaluated, if our work was subject to data analytics, on the one hand, this could help us to see the bias and the ways, direct and indirect, especially of discrimination. For example, if we could discover that we grade female students better than male without knowing why, maybe because we usually think that women work harder, so we evaluate their effort more. Although this is a sort of a bias, right? And without these data analytics, we would never ever see that. But on the other hand, this exposure, right? This labeling of a person that you have bias, you're discriminating others, could also be a reason to marginalize and to label this person, to turn this person into a scapegoat by the employer, who would, so to say, well, it's not me, it's just this individual who is discriminating, and I'm not in any way responsible for that. So that is why further complexity is introduced by the fact that we could also try, when we transfer this kind of data analytics to medicine, we also find ourselves in front of further complications related to informed consent of a patient. Basically, should this data analytics be accessible not only to the employer or the surgeon, for instance, but also to the patient? So success rates, whether certain, success rates on the basis of the age, of gender, of any other kind of measurement. So this, what I'm trying to highlight in my talk, I hopefully I'm succeeding, is that on the one hand, we could learn a lot. Things we like, things we do not like. But the question is whether what we learn might not be used against us, and whether we so to say, what should we do about that? I think that I'm in the right place to leave this question for just not to leave, but just to place this question here. And the huge question then is how we want to see employee analytics in general, from the judges to the surgeons, from nurses to teachers. So are we in front of advancements in mass surveillance, identification of people, of employees in this case, or we are actually promoting new levels of transparency, new forms of accountability? Do we want to legitimize profiling for a greater good, right? For a more just society, or we are commercializing justice and opening the black box of invisible bias and while revealing unknown levels of discrimination in justice, medicine, education, and many other fields. And well, that is it. Thank you very much for listening. And I think I also lost my words.
Thank you so much, dear Migle, for your very, very interesting keynote. Let's see if we have.
Migle, muchas gracias por su discurso. Yo hablo español también.
De nada.
Porque portugués es muy similar.
No, yes, that's very, very similar. And I also, well, it's I haven't been to Brazil. I was really envious of Theo Lynn. Professor Lynn seems like at home over there, but well, at least it was great to listen to Grazia Eleonora, because I had my PhD in Bologna, so 10 years over there. It was great to speak about the towers and, well, remember those years of youth.
Yeah, Barcelona is a great city. I've been there too, so it's you're
well,
always.
I see that Daniel is moving around.
I'm Portuguese too. I'm Portuguese too. I have nationality, so
okay.
I'm Brazilian, but I love Europe. Europe's a great place. But I actually lived in the U.S. for some time, not in Europe. And I love Theo because he's one of the few Irish that I can understand easily, you know, has a clear English. It's impossible to understand the Irish.
That's very true.
Only a Brazilian person would say that I talk clearly, but that's okay. I had a question for Migle. Do you think though that you can view? There's two questions. One is, I think that data analytics can be used as a support tool for judges and for lawyers, and not necessarily as a determinant of something. I think that has a lot of value. So for instance, I do a lot of work in Manaus in the rainforest about how we're going to use data science and machine learning and deep learning to support doctors in the rainforest, because they have a lot of endemic diseases that look similar, and machine learning is better at discriminating between different diseases than a human is. And I think that in the cases of, I think there's different variations of cases that you can apply machine learning to. So in the context of, I would say, very basic cases, I think like you can have parametric decisions where you can say, you did this, unless these particular instances happen, this is the determination. And then there's more complex cases where you need a human intervention. And I still think that there is a utility in having a tool that supports professional development and fairness that isn't necessarily determining an outcome. So I think that your point is there is some major questions if you have a deterministic approach to AI and you let it be autonomous. And then I think that they're related questions, because I think that it's there's a scale difference here. I think the big question is, if judges are accurate to a certain point, and when we deal with these things, we deal with sensitivity and specificity. So the degree to which something is accurate and precise and has true positives and things that have false positives and true negatives. And I think that the issue here is, if you found out that judges were only 70% accurate or precise or correct, and the AI is 85 or 90%, do you not think that a support tool for a judge to help them say, well, look, you're way off, whether it's sentencing, judgment, etc. I think that has utility.
Sure. Theo, I absolutely agree with you. So one thing is to use these systems for to help humans, right? I'm the first to say that, well, use anything you have, right? We have created them and we should use them. But I do have questions on using these systems against us in a way, right?
Well, I agree with that. I think a combative approach is wrong. I don't see value in using AI as a stick.
Mm-hmm.
It should be used. It's a bit like lectures. Do you remember when they used to say, oh, we want less of the sage on the stage and we want the guide on the side, mm-hmm. And mm-hmm. I think that AI should be a guide on the side, but should never be the primary focus of an activity which is critical. You know what I mean? So if it's surgery or it's the law, I think that there's a degree of criticality and then there's a degree of centrality. Mm-hmm. And I don't think that AI necessarily should be central where you have high criticality. And so if you imagine
also much so that, oh, sorry.
No. I was just imagining a grid where you have criticality and centrality moving in two axes. And there's probably scenarios that you could split up in terms of the context of a case and the sentencing. And they're two very different things that you're looking at with AI, and that you could classify those things into what would be AI first and what would not be AI first, and what requires explainable AI and what doesn't require explainable AI. And I think there's a discussion to be had in legal circles around the nuances of those boundaries. And once we identify the boundaries of those things, I think that you can have even better discussions about where you draw the line without getting into casuistry or sophistry. You know what I mean? So it's very important that we don't get into a point where we're just coming up with reasons not to do something. But the way I was thinking about your last question was to view this more as talent analytics and not employee analytics. That judges and lawyers are not Amazon warehouse packers. They're people who were asking to make a judgment on behalf of society against the context. And so unless we want to take the humanity out of that, which I don't necessarily think is a good thing, you need to have the support infrastructure to help them make sure that it's fair. Anyways, that was my comment.
Yeah, thank you very much. I agree with what you're saying, so much so that the point that, well, the question is, well, the judge is something more than just the state employee, right? So yes. I'm sure that there are both opinions for and against, right? That they are something more. Yes, their salary reflects that they are something more, but then.
Well, they're a pillar of society. In Ireland, they're separate to the government, and so I think that they have a societal role and then an employment role. And society has to ask themselves, if that's the role, if you want judges to have a societal role, this is what that means. The employment aspect, I think, is similar to academics and academic freedom of speech and academic tenure, etc. That if you want academics to explore different things, they need a certain freedom, and there's going to be things that go right and things that go wrong. So there's a fluidity in that. But I wouldn't view the AI decision about employee analytics. I view it as a kind of a system analytics thing, in that kind of context, that the judge is representing a system of justice, as opposed to them as an employee. The employee aspect is slightly different. It's separate to their judgment. If they don't turn up at work every day, I think that's fair enough. Or if they, if they take bribes, that's an employee issue. But their judgment and how they approach cases is more of a process and system of justice issue, and therefore it's kind of a different context, and that's why that criticality, I think, is really, really important as an attribute.
Oh, thank you very much for your opinion on. Well, I think I don't have time to we could continue, right? We could spend here the rest of the conference debating where and how we should draw the lines between these concepts, but I guess we are running out of time. So thanks again for letting me talk to you and present my work and listen to you as well, because it's a pleasure. And I will reconnect again after the class. Okay. Thanks a lot.
Thank you so much. Thank you, dear Migle. I know you have a class, so you have to go. Thank you.
Thank you. Bye. Bye.
Yes, we have amazing speakers today. And last but not least, I want to introduce you to Professor Francesca Ferrari. She is from the University of Insubria from Italy. We actually also met with Professor Ferrari for 3 or 2 years ago, yes, in the University of Bologna. I was just a listener in this summer school, but Professor Ferrari was the lecturer, and I was really impressed by her professionalism and by the topic she's researching, and she's also the practicing lawyer, so she's a specialist in civil procedure and in the intellectual property rights. So, dear Francesca, the floor is yours, and we are eager to listen to you.
Thank you so much for your presentation and for your invitation. I had the opportunity to listen to the 2 speeches before mine, and actually what I'm trying to emphasize in my, I do share all the considerations with respect to algorithm in decision making. So about robo judges. On the other hand, as Professor Lynn was trying to, I think, to emphasize, there are also some specific issues with respect to which artificial intelligence is, and generally speaking, new technologies can be particularly helpful. In quite a recent book, I emphasized the relevance of artificial intelligence and new technologies in the evidence phase in civil proceedings. Now, what I'm trying to, the subject of my speech is going to be, I'm sorry, I'm trying to put the presentation on. I'm not so good as...
We can see it, everything is fine.
Okay. What I'm saying, what I'm trying to, just one second, sorry. What I'm trying to talk about is the possibility to use, as I said before, new technologies and artificial intelligence in order to protect rights. The subject is the liability of internet service providers and dynamic injunction. I don't know how to go further, but I'm trying to understand. No? Okay. So my question is, the question I'm trying to answer is it possible to impose on the internet service providers measures capable not only to stop violations of intellectual property rights on the internet, but also to prevent new ones? And clearly, in order to introduce this subject matter, we need to emphasize the fact that with the e-commerce directive, it was provided that the member states shall ensure that the service provider is not liable for information of third parties that it stores or transmits. Actually, the e-commerce directive followed expressly a press release by the European Commission in 1998, through which the European Commission announced that it was going to introduce a new law establishing an exemption from liabilities for intermediaries, where they play a passive role as mere conduit of information from third parties, and moreover, to limit service providers' liability for other intermediary activities, such as the storage of information. It has to be mentioned that within the e-commerce directive, there are also some forms of liability that are not exempted because each safe harbor includes a legislative carve-out for a possibility for a court or for an administrative authority in accordance with the member states' legal systems to require a service provider to terminate or prevent an infringement. But actually, this apparently is the main rule is the rule I talked before, and this is clearly expressed in Article 15 of the e-commerce directive, entitled No General Obligation to Monitor, which provides that member states shall not impose a general obligation on providers to monitor the information which they transmit or store, nor a general obligation actively to seek facts or circumstances indicating illegal activity. It has also to be mentioned that those principles on ISP liability, or better to say non-liability, had been confirmed by the Court of Justice, by the European Court of Justice. And the first case we had to, I think it is opportune to quote, is the Scarlett decision of 2011, establishing that the European legislation does not allow to impose on an internet access provider to set up a system of filtering of all electronic communications passing through its services, in particular through peer-to-peer programs. Therefore, an injunction that applies indiscriminately to all users of the ISP, a preventive measure, cannot be considered compatible with the European rules. Actually, a measure of this magnitude, such as, I'm sorry, I don't know what I did, a measure of this relevance would be in clear contrast with the principle quoted by Article 15 of the e-commerce directive. The same principle already stated by the European Court of Justice in the Scarlet case had been repeated by the European Court of Justice in the so-called Netlog case. In this specific case, the Belgian Collecting Society had acted to obtain the application of a filter on the content hosted by the social network platform managed by Netlog. And the purpose was to identify the content owned by the members of the Collecting Society, conveyed on the social network, and this in order clearly to prevent its circulation among the users of the platform itself. Notwithstanding some really real differences between the Scarlet case and the Netlog case, the decision by the European Union Court of Justice was exactly the same. And why there are some differences that had not been evaluated by the Court of Justice? First of all, because Scarlet is an ISP, so it transmits information in communication networks and provides access to these networks, but does not store information unless for transmission efficiency only, so in a temporary way. Scarlet is a mere conduit as regulated by Article 12 of the e-commerce directive. Netlog, on the other hand, is an hosting service. It owns a social networking platform, stores information provided by the users on its service. It is clear that from a technical perspective, and I deem that Professor Lynn would know much more than I know, but filtering communications in a network is very different from scanning one's own service content. But those differences had not been evaluated by the Court of Justice, and actually not been evaluated either by the European Union lawmaker with the e-commerce directive. Why? Because Article 15 of such directive provides for a prohibition to impose a general obligation of monitoring and does not make any distinction between ISPs and hosting service providers. Which was exactly the view of the Court of Justice. As I said before, the Court of Justice didn't give any relevance to this technical distinction and issued two almost identical decisions, stating explicitly that it was impossible to impose any kind of filtering or monitor obligation on Netlog or on Scarlet. And what is striking is that is this similarity between the two decisions, and it can be seen also by the fact that the whole part of Netlog decisions outlining the considerations of the court, the ratio, the argumentation of the court, had been literally copy-pasted from the Scarlet decision. Actually, this position, as I said before, the position that comes out from the e-commerce directive and that had been confirmed by the European Court of Justice is considered consistent, obviously, with the constitutional legal framework set up by the European Convention of Human Rights and by the Charter of Fundamental Rights of the European Union. And clearly, it has to be mentioned that the fundamental right to freedom of expression provided for by the convention I named before and the charter I named before does not only guarantee the right to impart information, but also the right of the public to receive such information, including the right to internet access. This right to internet access is becoming and became fundamental in the eyes of many. Which is the rationale behind the right to internet access? Is that the internet, by facilitating the spreading of knowledge, increases freedom of expression and value of citizenship. And this had been confirmed by the Council of Europe and by the same European Court of Human Rights with several judgments specifying that the right to internet access is to be considered inherent in the right to access information and communication protected by national constitutions, and moreover encompasses the right for everyone to participate in information society. It is clear that according to this framework, any action that could affect the accessibility of the internet has to be considered an interference with the rights guaranteed by the European Convention of Human Rights and by the European Charter. Many scholars with respect to the right to internet access, emphasize that websites benefit from the protection under Article 10 of the European Convention, since any restriction imposed on the possibility to access internet necessarily interferes with the right to receive information. And the same European Commission stated that any limitations to access to the open internet can impact on end users' freedom of expression and the way in which they can receive and impart information. From this point of view, I'm sorry, I do not have a slide, but what is relevant is also the quite recent directive on copyright and related rights in the digital single market, Directive 790 of 2019, because Article 17.4 emphasized the fact that with respect to the use of protected content by online content sharing service providers, this article emphasized the fact that if no authorization is granted, online content sharing service providers shall be liable for unauthorized acts of communication to the public, unless the service providers demonstrates that it has used its best efforts to obtain an authorization or other circumstances that can limit its liability. So situation is changing. And situation why is changing? Because the rapid growth in technology has created clearly with the web a unique landscape for creation, exchange, and consumption of content. We heard before by Elena all the different things that can be done with these new technologies. And this is true not only from the academic point of view, but from all point of view. So while all these new technologies made communication more amplified and convenient, it's clear also that these new technologies significantly compounded the existing issues faced by intellectual property holders with respect to piracy of their work. So the question is it possible to obtain blocking injunctions against internet service provider and so to obtain something not from the violator of the intellectual property right, but from the intermediary? Actually, why it is so important to answer this question? Because digital piracy benefits from potential shields of anonymity, of non-traceability, and a quicker bounce back ability. Even when websites hosting and sharing pirated content are blocked, they often resurface as mirror alphanumeric websites having the same infringing content. So the concept of blocking and dynamic blocking injunctions had been developed with the aim of addressing precisely this issue. The framework for dynamic injunction was first devised comprehensively by the High Court of Singapore. High Court of Singapore had to face and to address the issue of flagrant infringement on digital platforms and observed that it has the jurisdiction to issue a dynamic injunction given that such an injunction constitutes a reasonable step to disable access to the flagrantly infringing online location. This is because the dynamic injunction merely blocks new means of accessing the same infringing websites rather than blocking new infringing websites that have not been included in the main injunction. So according to this first blocking injunction, dynamic blocking injunction, the purpose is to issue a dynamic injunction merely blocking new means of accessing the same infringing websites, but not blocking new infringing websites. Coming back to what we know more, and I mean the European Communion, the point is, have the blocking injunctions any recognition by the law? Yes, they have. And they have it in the InfoSoc Directive and the Enforcement Directive. So although these blocking injunctions are not implemented and applied in a uniform manner among the European Union member states, although only in very few cases there are specific law provisions explicitly recognizing blocking injunctions in the member states, then we have to say these blocking injunctions are compliant with European Union legislation. What does blocking injunction means? And what is the difference between blocking injunction and dynamic blocking injunctions? Blocking injunctions refers to an order that requires an internet intermediary to implement technical measures directed at preventing or disabling access to a specific internet location. Internet site blocking injunction can be implemented, and I hope I'm not saying something that Professor Lynn will challenge on the basis of his specific knowledge from this point of view. It can be implemented through DNS blocking, through IP address blocking, or through uniform resource locator filtering. As I said before, blocking injunctions is referring to a specific internet location. Thus, it does not refer to possible new specific internet locations having the same pirated or counterfeited content. In view of this, in recent years, a second category of blocking orders had been considered available in many European Union member states. These orders are called forward-looking or dynamic blocking injunctions, and they are meant to allow flexibility to cover repeated infringements and, in a certain way, to enhance the effectiveness of the measures for right holders. But then we talked about blocking injunctions, we talked about dynamic blocking injunctions. We need to talk also about live injunctions. Why? Because national case law has been increasingly concerned with blocking injunctions for combating illegal broadcasting of live mainly sports events, including clearly online transmission, so Internet Protocol TV or IPTV. Some European jurisdictions have thus made available live blocking orders that have the principal goal of limiting or avoiding infringement of right to live sport events. These orders have two main characteristics. They wholly have effect at the times when live match or live event is being broadcasted. These orders allow new servers to be blocked every week to prevent the continued infringement of IPRs. But on the other hand, they only come into force when the broadcast is in session. As I said before, the legal basis for blocking injunctions can be found in Article 18 of the E-Commerce Directive, but also and mainly in Article 8.3 of the InfoSoc Directive and in Article 11 of the Enforcement Directive. I'm not going to read those articles. I think we know all of them, or we can simply go there and find the exact wording. What is relevant is that the compatibility of blocking injunctions with the European Union law does not only comes from not only come from the articles I mentioned, but also from a number of Court of Justice judgments, which also supports the availability of dynamic blocking injunctions, although in specific situations. Mainly, the Court of Justice, first of all, confirmed that the notion of intermediary is broad, encompasses internet access service providers, which is relevant for our purposes. Moreover, in a very well-known decision that is UPC Telecable on March 27, 2014, the Court of Justice stated explicitly that given that the internet service provider is an inevitable actor in any transmission of an infringement over the internet between one of its customers and a third party, since in granting the access to the network, it makes that transmission possible, it must be held that an internet service provider is an intermediary whose services are used to infringe a copyright or related right within the meaning of Article 8.3 of the InfoSoc Directive. Moreover, in a later case, McFadden in 2016, the Court of Justice clarified that the mere conduit exemption pursuant to Article 12 of the E-Commerce Directive does not preclude a person from claiming injunctive relief from an access provider against the continuation of an infringement occurring through that access provider's network. Finally, the Court of Justice made clear that blocking orders would fall under Article 8.3 InfoSoc Directive and Article 11 of the Enforcement Directive, and thus are compliant with EU law. In a certain way, with these decisions, and I talked mainly about, I was mentioning mainly Telecable and McFadden, the Court of Justice recognizes that those injunctions must be available in member states to order an access provider to prevent continuation of the infringement. And this implies that copyright holders can seek injunctions to stop future infringements, given that these injunctions respect, according not only to the EU law, but also to the EU interpretation of the law by the Court of Justice, respect the balance between the interests at stake and protect fundamental rights. The Telecable decision played a relevant role also in potentially supporting the availability under EU law of dynamic blocking injunctions, which, as I said before, are broader injunctions that impose an obligation of results via the blocking of identical or equivalent websites with different IP addresses or URLs, rather than a narrower obligation of using specific technical means to block a specific IP address or a specific URL. A further case we can remind is the L'Oreal case, through which the Court of Justice specified that injunction pursuant to Article 11 of the Enforcement Directive must be available to take measures which contribute not only to bringing an end to infringement, but also to preventing further infringements of that kind. The articles I mentioned before and these decisions by the Court of Justice confirm the availability of dynamic injunctions. And actually, blocking injunctions have been recognized in recent years, first of all, by the English courts. We cannot avoid to mention the Cartier judgment, with which Judge Arnold of the English High Court affirmed the existence of English jurisdictions, and specifically said that once an ISP becomes aware that its services are being used by third parties to infringe intellectual property rights, then it becomes subject to a duty to take proportionate measures to prevent or reduce such infringements, even though it is not itself liable for infringement. So the English court identifies the conditions for the emission of the order. The matter has to be directed against an ISP copyrights have been infringed by users and/or the operator of the site in question through the service offered by the ISP. The ISP has an actual knowledge of the infringement, for example, through a complaint by the rights holders. So notwithstanding the fact that blocking injunction can be considered nowadays a reality in the context of the EU member states, we cannot avoid to mention that among the different European Union member states, the requirements for getting those injunctions are different, and there are several points that should be better evaluated and analyzed, also in order to get to an harmonized situation for blocking injunctions. First of all, I'm trying to go as fast as possible, but I want to emphasize that there are many differences between the different member states' evaluation of blocking injunctions and application of blocking injunctions. Then there are some also similarities between among the different member states. First of all, to guarantee proportional balancing of fundamental rights, dynamic blocking injunctions must be consistent with the constitutional legal framework. And from this point of view, courts must assess the proportionality of the measure according to Article 3 of the Enforcement Directive and the general principles of the EU law. This is normally done on a case-by-case basis according to several national standards. In all member states, fundamental rights must be considered by courts when balancing rights and interests. And dynamic injunctions should also address the risk of over and under blocking. Static and dynamic blocking injunctions should be made available only if they are strictly necessary or targeted to bring the infringement to an end, and if they do not disproportionately impinge on fundamental rights. As I said before, there are also some common general requirements and procedural rules that apply in most member states to get those injunctions. The need to demonstrate right holder status and ownership of rights, evidence of alleged infringement, a decision on the merits, proceedings to obtain a blocking order can be ex parte and inter partes in some member states, intermediary contributor liability is not requested for imposing blocking injunction. So what I'm saying is that there's no liability of the intermediary. The temporal validity of blocking injunction is not explicitly limited, while in some member states an unlimited duration is applied with caveats. Then a further point that should be evaluated is that dynamic injunctions do not have any explicit statutory recognition. Courts have been granting those injunctions on the basis of an expansive interpretation of pre-existing norms. And the same is true also for live blocking injunctions. Moreover, with regard to the scope of dynamic blocking injunctions, subject matter, targeted intermediaries, targeted websites, temporal and territorial scope, they vary to different extents in the member states. Procedural rules, as I said before, there are some procedural rules that are common, but there are no specific procedural rules on the requirements for any admissibility of evidence for blocking injunction in the different member states. And this is true not only for blocking injunction, but also for dynamic blocking injunctions and for live injunctions. In a certain way, courts are clearly applying the normal procedural rules, the normal evidence rules, but sometimes this should be adapted to the new world in which they need to operate. Moreover, it is important also to evaluate the available mechanisms to address blocking of illegal content. IP address and DNS blocking are the most common technical solutions, but there can be others. Another point that has to be evaluated is the allocation of the costs for implementing blocking measures. Then there is a further point that concerns the extraterritorial scope of injunctions against online intermediaries, because we need to move from a territorial vision of IPR. We need to move from the doctrine of comity to a location that's not a location like the internet. And from this point of view, the Court of Justice recently concluded also that EU law does not impose or preclude worldwide measures, but clearly we needed to find rules to have worldwide measures efficient. An additional important factor is also, as I said before, to evaluate effectiveness of these blocking injunctions. And for the time being, this kind of evaluation had been carried out only in the UK and in the Netherlands. What can we say trying to conclude on this matter? I'm sorry if I was too fast, but I wanted to give you some points on this issue without annoying too much. The positive outcome related to the availability of blocking and dynamic blocking and live blocking injunctions is that the use of those, the possibility to issue these injunctions is clearly related to the availability of technological means through which these injunctions can be effective. Thus, in a certain way, we cannot avoid to recognize the role that new technologies and/or artificial intelligence systems can play in civil proceedings in order to protect fundamental rights as copyright. It is also clear that we need to recognize that jurists must equip themselves, and this not only with anthropological skills, but also with technological skills. And in a certain way, for at least for lawyers, it is necessary to change the attitude and to evaluate the use of the new technologies in legal proceedings not only as one of the annoyances that undoubtedly afflict the legal profession. We have only to think to all the filing through telematic process and all the bags we had in telematic process, at least in Italy, to understand why I'm talking about annoyances. But the jurists should also, the lawyers should also take this new role of the technologies in legal proceeding as an opportunity for improvement in terms of quality of the process of justice and the due process of law. In a certain way, as I said before, I was trying through the dynamic blocking injunctions to emphasize that artificial intelligence systems or new technologies can not only can have a specific roles in civil proceedings, or as it is in this case, in the enforcement of civil orders that constitute the other one with respect to all the difficulties that new technology poses when we think the use of them as substitute of human beings' activity. Thanks so much.
Thank you so much, dear Francesca. It was very, very interesting keynote. Maybe, do we have any questions?
Before the question, Elizaveta, I would like to thank the organizers and the sponsors of the conference. You know, they made this happen. First of all, the organizers, South Ural State University, my dear Susu, thanks for all the support from Russia. Please thank your dean, the Professor Titova. She was very kind also, and all the professors and all the Russian academic community. My university Candido Mendes here in Rio de Janeiro, my master's degree program. We are trying to establish this international partnerships, and they are really important for the BRICS and for our countries, Brazil, Russia, India. We have a lot of Indians participating here, and so this cooperation really is the way forward, as the name of our conference is saying. And Umbra University, which I'm also glad to be a professor, an arbitration professor in the master's degree. It's a university in Orlando, Florida, and their support was really awesome, and they really did this conference happen here. And I hope soon enough, Professor Elizaveta will also be a professor at Umbra University teaching digital technologies, which I invite you all to attend her course. I am sure gonna be in the first row to watch her classes there. And the partnership of the BRICS Law Journal. So I thank again Elena, Professor Elena, for her kindness. And of course, Eleonora, thanks a lot for the University of Bologna Law Review partnership. And you guys were great. And the success of this conference is really because of both journals and the partners. Of course, my journal, the Brazilian Journal of Alternative Dispute Resolution, one day we're gonna be like you guys, the Scopus, but now we're just a journal in the 6th issue, but we're getting there. We're gonna get there someday. And also the sponsors, A2DL Consultoria, which is, I'm gonna speak in Portuguese here, consultoria especializada em compliance and proteção de dados. They are specialized in compliance and data protection. The website Direito Profissional, which is professional law translated to English, which is a law tech of content education and mentorship in compliance, ADR, and office, law firms, management, and last but not least, MoMA Law, Muller Mazzonetto law firm here in Brazil, which practice intellectual property, ADR, alternative dispute resolution, technology, and basically, so these are the partnerships and the sponsors of our conference. Thanks everyone for believing in this project, and may this one be the first version of many to come in the next few years. So thanks everyone. Please, Elizaveta, the floor is yours again. Sorry for interrupting you.
Well, thank you so much, dear guest of honors. It was a really, really big honor for all of us to listen to you. So thank you so much that you have the opportunity to share the results of your research. I was really enjoying with your keynote and learn a lot from you today. Thank you so much, dear Eleonora. Thank you, the University of Bologna Law Review. I'm really, really happy that we are establishing our cooperation, and I'm sure we will develop this cooperation further. Regretfully, Elena had to leave, but thanks to Elena Gladun, the editor-in-chief of the BRICS Law Journal, we also developing our cooperation, and I'm sure we will develop it further. So thank you, dear speakers. Thank you, Professor Lynn. Thank you, Professor Ferrari. Thank you, Professor Laukyte. We will meet tomorrow when the session starts. We are having 9 sessions with amazing keynote speakers, because we do have something about 108 participants and 78 abstract submissions. So that is why we have these 9 sessions with very extremely professional moderators. So see everyone tomorrow at sessions. Thank you so much. for your time, for your support, and for your friendship. Bye-bye.
And come to Brazil. We are waiting here.
You also can come to
like.
Russia is also good.
Thank you. Bye-bye, everybody.
Bye-bye.
Bye. Thank you.
Bye. Bye-bye. Thanks.
Thank you.